May it please the court. Good morning. I'm Joe Eagleton with the law firm Brannick and Humphreys, and I'm here today for the appellant Comprehensive Care Corporation, who's referred to in the briefs as CompCare. If I could, Judge Valenti, I'd like to reserve 3 minutes for rebuttal.
You got it.
Thank you. This is a breach of contract case where the bargain that the parties struck is clear. As the court no doubt noticed from the relatively lengthy record in this case, the parties have been engaged in some rather acrimonious litigation for years. And so in exchange for everyone agreeing to put down their swords, each side gave up and got something pretty significant. And so what the agreement here was that CompCare would agree to pay a specific sum of money, which was $800,000. They would agree to do it by a specific time, which is 18 months from when the first payment was due. And they agreed to do it in a specific manner, which was to make monthly installment
payments. And
then
they negotiated the word equal installments out.
Yes, Judge Valenti.
And then the judge, you believe, wrote that back in, and therefore the judge rewrote the contract, and therefore you can't do that. Even if you're a judge, you don't have that kind of power.
Right, of course. So
let me ask you the question then. The judge seemed to focus on another aspect that neither side argued, but it's fair game. He could have injected this. When he was trying to make a decision, he used the word reasonable installment. Now, I believe he could inject the word reasonable, and so my question would be, could he? Or is that still a violation of an unambiguous contract? You can't use the word reasonable, or is that implied by the case law that you can inject the word reasonable performance in good faith?
it's still a violation of the contract and still a rewrite of the parties' agreement. So the cases that the trial court relied on, where courts have imputed some kind of reasonableness requirement in, are cases where the parties have not agreed about when the contract needs to be performed. And
well, they agreed in this case. There's
right.
Either going to be a balloon or it could be paid off sooner.
Right, and if 18 months had gone by and it still hadn't been paid off,
well, 17 months had gone by when the trial occurred, right?
Well, only 2 months.
The judge said you only paid 21%. Who are you kidding here? You have no shot at paying us off in time.
Well, Judge Valenti, only 2 months had gone by when KATZMAN sued CompCare for breaching the agreement. So I think it's certainly not unreasonable that the amount of the payments would decrease.
But they still made payments.
They were still attempting in good faith to make a monthly payment, but I'm not sure they were required to do that.
Do you call a $150 a month payment good faith? $350 a month good faith? Make it out to someone that you asked not to make it out to?
Well, I think there's a couple of questions in there. So first of all, I would say that after they were sued, only 2 months in, the first payment was $10,000. That's a far cry from $150. So
can I ask you another question? Because was there economic testimony that the $500,000 profit was no longer in play? Or was that payment made based upon a due date? You make the first payment by so-and-so date, or when they hit the $500,000 profit?
I don't think it's disputed that when the first payment was made that was an appropriate time to start making the payment. So I don't think that $500,000 was in play. So they made the payment at the March 2015 date when the contract specified it would be made if the $500,000 that you're referencing was in play.
So the defense was not that we couldn't reasonably pay higher amounts, but we didn't have to. We could pick whatever amount we wanted to pay as long as we paid it off in the 18 months.
Well, it was both. The whole reason that the agreement was structured the way that it was to give CompCare the flexibility to make the amount of payment that they could based on their financial situation at the time. This is why, and
now, the testimony supports that, correct?
Yes.
But the actual agreement doesn't really say this in those so many words.
Well, the agreement says 18 monthly installments.
And what we're reading into is an interpretation there. It didn't say, we'll pay whatever we want as long as we get the whole thing paid off. And that's where the judge said, I'm going to read the word reasonable in. And you're saying that's not fair.
Well, the agreement didn't say equal payments, and it didn't say reasonable payments. It said 18 monthly installments. And so we'd have to look and say, well, what is an installment? And as we detailed in some length at the brief, there's virtually unanimity among plain language dictionary definitions that an installment does not mean an equal installment. It doesn't mean a reasonable installment. It just means a periodic partial payment of the debt. So
the good faith aspect of the case law that says I'm going to read into any agreement an obligation to deal in good faith and fair dealing you're saying that can't be done here.
Certainly.
And I always read that case law say that you can do that in any kind of contract.
Well, it can't be used, Judge Valenti, as an independent basis to find a breach of the agreement, which is what the trial court did here. The trial court said the only breach that ComCare committed was by not making payments in what he called good faith. But what he basically meant was the payments weren't enough. But what's enough? I mean, there's no dispute that ComCare was making a monthly payment. There's really no evidence that ComCare wasn't acting in good faith. Again, the first payment was for $10,000. Everybody knew, it was among these parties who had been in litigation for years, that ComCare's financial situation was not good at the time. This is the whole reason. In fact, it was so not good at the time that ComCare was willing to give up a pretty significant
judgment, the $1.2 million.
Right, the seven-figure judgment, and to go ahead and issue warrants for 1 million shares of stock, which is something that, the stock issue is something these parties have been litigating for years. So it was.
What's the remedy you seek today? What do you want us to do? Reverse it for what? What's your remand look like?
It's a reversal and a remand for entry of an involuntary dismissal on their breach of contract claim because they completely failed to meet their burden to establish that ComCare breached the agreement. And it's a reversal and remand on the second issue we raised, which sort of ties in because ComCare alleged a counterclaim for breach of the agreement. So this makes a big difference because the trial court's finding of breach, that ComCare breached by not making these what the trial court just decided were unreasonable payments without any evidence, carry with it some significant repercussions because it was the sole basis.
There was a trade secret allegation that was breached, trade secrets, but they had to file an agreement because they were compelled to file it before the court would make certain rulings.
Something like that, Judge
Something like
Lane.
that.
Right, correct.
Break that down.
Confidentiality clause in the agreement, is that?
Correct. There's a confidentiality clause in the agreement, Judge Atkinson, that said that required this agreement to remain confidential. And KATZMAN entered that agreement into the public record as part of the trial. And I think.
Because of why?
Well,
why did he do that? Was he required by the judge to do that?
I think the reason that it was entered into the record was in an attempt to try to prove the claim of breach, but as the trial court noted at the time, that carries some ramifications with it. If you don't establish breach, but you have now entered this agreement into the public record, then you yourself.
Back in play on a reversal?
Yes, Judge Delancey,
Yeah,
we
but
do.
when you file a breach of contract action, aren't you required to file the complete entire contract?
Ordinarily, Judge Slee,
Well,
yes.
that would include your confidentiality provision then.
Well, I think that they attempted to submit it in camera initially to the judge, but at the point when they entered it into evidence, into the public record, our position was that that amounted to a breach.
They attempted it, and there's rules of judicial administration that provide for just this scenario, right? That if you have something you need to submit as a attachment to a filing, that and you said they did go through that procedure?
I think initially they attempted to enter it in camera, but the settlement agreement, our position is the settlement agreement was entered into the public record in this case. It is part of the court file. This court file is not sealed. It is now part of the public record. So,
Well, I don't know if we need to resolve that. Can I ask you a question about the contract itself?
Sure.
Leaving aside the parole evidence that you're contending ought to have been considered. The paragraph 2 says it's 18 monthly installments. Paragraph 4 talks about a default under paragraph 2, and then it balloons immediately to $800,000. They're entitled to a judgment for $800,000 on a default. So the parties contemplated that one could default on the monthly payment. I could understand one way they could default, which is no payment. But it seems intuitive to me that I guess I want to ask you, if they paid 1 cent a month, would they avoid the default in number 4?
well, I think, first of all, they didn't pay 1 cent a month, but they paid $10,000.
But that doesn't really matter. We're doing,
Sure.
Interpreting
I think the answer.
what the parties contemplated would be a default.
Sure. I think the answer to your question, Judge Atkinson, is yes, because what the parties agreed on was to give CompCare flexibility to structure these payments based on the financial health and condition of the company. They say 18 monthly installment payments. It would have been very easy if the parties had intended to specify some minimum threshold of payments that CompCare needed to make, and they didn't do so. And so, at best, paragraph 2
This is another way of looking at it. So if you look at that default provision, it sounds like you're saying you owe 18 cents total, unless you want to give a fraction of a cent. And then by the end of the 18 months, you owe 800,000. If you're in default, you owe 800,000. That doesn't make any sense. What makes sense is that you owe there's some way to default each month. There's some way to default by the end,
Well, first of all,
why is there default at all if it was completely discretionary?
Well, it wasn't, first of all, I'd say no one has made this argument in this case at all. No one has raised this argument.
I know that.
But if CompCare had failed to make a payment, that would have been probably a default. They were required to make a monthly payment. And so when it says if in default under number 2,
Doesn't it also suggest that the parties intended for there to be some predetermined payment? If there's a default that can occur prior to, essentially what you're saying is you have to pay $800,000 at the end as long as you paid 1 cent a month. Isn't the more reasonable way to understand the agreement of the parties that if they contemplated a default prior to the $800,000 being due, it must be that they expected that there was a certain amount due each month, and if that wasn't paid, there would be default, which would entitle the other party to judgment for the entire amount.
I'm not sure it's clear what the party, on that point, why that provision is in there. No one has discussed it or talked about it, so I'm not sure. What I would say is clear is that the only evidence we have suggests that there was a reason they did not require the payments to be in a specific amount. There was no evidence or testimony presented by the plaintiff, KATZMAN, in his case in chief, about the intent of the parties in negotiating this. No evidence presented about some minimum payments that were due. No evidence presented about what the damages supposedly were that were suffered because of these payments not being in equal amounts.
Let me ask you this. You're not challenging the introduction or the consideration of parole evidence, are you?
No, Your Honor.
Okay, so that's not an issue. So now you have a trial court who is sitting in a non-jury trial, and he takes testimony about the negotiations, the nature of the negotiations, the reason why they, structured this particular agreement the way they did, and the need for delay, and the unavailability of funds, et cetera, et cetera. So here you have a judge listening to all of this, and he's also concluding that the plaintiff's theory and the defense theory makes no sense. They're inconsistent. And he also concludes that the parties may not have been bargaining in good faith. How is that an erroneous conclusion if you allowed the parole evidence in, you did not object to it, it is not an issue on appeal? How is that an erroneous finding by a court when presented with that type of testimony, and the court's responsible for reaching a conclusion as to whether the parties, what they intended? Part of the process of interpreting a contract by a trial court, you take in consideration the party's testimony. Why can't the court consider whether they negotiated in good faith? Because the court does make certain conclusions here that the plaintiff's argument about the word equal is untenable. The defendant's argument that the court should read the word installment out is also untenable. The theories are inconsistent. Court concludes that the instance the defendant deliberately left the language sufficiently vague that litigation was all but certain. Those are all conclusions drawn from parole evidence that you do not dispute. So tell me how that's erroneous.
Well, Judge Sleet, so the first question, the first job of the trial court is to look at the language the parties actually use in the agreement and decide, does that provide the answer? If parole evidence is to be considered, the parole evidence is to be considered to determine what was the party's intent at the time of negotiating the agreement. And the trial court also...
But you allowed parole evidence.
Sure, but
So what you did was you basically waived the argument before the trial court that he was confined to the language of the agreement. You
Well,
opened it up.
First of all, let me back up 1 second. None of the parole evidence came in until the plaintiff had rested his case in chief, at which point we moved for an involuntary dismissal. So at the point where we were alleging the trial court first committed an error and should have granted our motion for involuntary dismissal, there had been no introduction of parole evidence. The plaintiff had said, this agreement unambiguously says that 18 monthly installments means 18 equal monthly installments, and presented no evidence of that, no testimony about that, no testimony about damages. And so CompCare moved for involuntary dismissal and said, you didn't prove your case. The trial court denied that.
It's a pretty low standard whether they proved a prima facie case. Court can't weigh the credibility of the witnesses or anything, or the sufficiency of the evidence. It's just whether they proved a prima facie case.
Well, their case was pretty simple, Judge Sleet. It was 18 monthly installments means 18 equal installments, and it doesn't. And they didn't present any contrary evidence to show or support their interpretation of that agreement. So the trial court denied. So at that point,
Had they put on other evidence that KATZMAN had some other expectation other than equal monthly installments, and then that would have given the judge something to say, well, that's a reasonable interpretation, therefore you breached the duty of good faith. It wouldn't just be an independent breach, it would be a breach of the expectation of the parties. But he was adamant it meant equal.
right. Right, they took a hard line, KATZMAN took a hard line approach to this case to say it means equal, but it doesn't mean equal, as we've shown.
The judge didn't buy that.
Correct.
But the judge did buy. I'm not sure where the line is as to what a reasonable payment would have been, but I know this was well below the line of reasonable.
Right, I think this is an important point to note about when we're talking about good faith. Judge Lee, you said that the judge found that CompCare wasn't bargaining in good faith. I'm not sure what relevance that has to whether the contract the parties agreed on is breached. When the trial court said CompCare breached...
You can agree anything in a contract as long as it's not illegal. So your contention is KATZMAN may have made a bad deal, but that's not my problem.
Sure, exactly, Judge Valenti. And so what the trial court really meant by breach of the duty of good faith and fair dealing was the payments weren't enough. But the trial court, how do we know what amount was supposed to be required? If the parties wanted a minimum amount of payments, they would have specified what the amount of that payments was.
The court was saying breach of the duty to perform in good faith and fair dealings. The payments were inadequate, and we don't know what adequate would have been, but that's what the judge went off. And your main argument is that's an independent basis that is not permitted to support a lawsuit. You need to have a breach of the contract, then you can argue these other things as a corollary.
Correct.
Am I understanding you correctly?
Yes, Judge Valenti,
You're
that
at
is
2
our...
minutes. I didn't mean to cut you off, but you want to keep going? Or you want to save the 2
I'll
minutes?
save the rest of that time
Okay,
for both.
thanks.
Thank you.
May it please the court, Russell Landy from Damien Valori on behalf of plaintiff Dr. Jerry Katzman.
Do you mind giving me your name one more time?
Sure. Russell Landy,
Spell that.
Landy.
Oh, you filed a notice of appearance. Okay.
I did, Your Honor.
Okay, I'm sorry. I should have seen that. All right.
No problem.
Do you want to start with the $64,000 question? Was the judge authorized to read in a fair dealing and good faith performance of a contract without an independent breach?
Absolutely. Well, I don't think there was an independent breach.
You're going to find
Yeah.
fault with the second statement. There was an independent breach, which
Correct.
was what?
The breach of the payment obligation.
Okay, now you're still going with the equal payments, that even though equal was not in the contract, this was supposed to be equal installments?
Well, I think that there's a reasonable reading of the contract that this is supposed to be equal payments. Between the two interpretations, between Dr. Katzman's and CompCare's, it's more supported by all of the other things in the contract, which I can get into. But to answer your question directly,
Get me by
Yeah.
the following sequence. I'm drafting the agreement. I put in the word equal. Send it to the other side. They say, what are you, crazy? Get that equal out of there. We're not agreeing to equal. We'll do it and they don't use the word balloon, but we want to have the option to make a balloon payment, make whatever amount we want for 17 months, and then make 993,000 at the end and give you $1 a month. That's what they say that contract unambiguously says.
And what that would mean is CompCare would have the discretion to determine the amount of the monthly payments. And in order to exercise that discretion, they would have to do so exercising the duty of good faith and fair dealing and in a reasonable manner as provided in the cases.
So you agree there's a duty of good faith and fair dealing?
Absolutely.
Okay. Do you need a separate breach before you can assert that?
I think that by not operating in good faith and fair dealing and exercising that discretion, they are breaching the payment obligation. The payment obligation was, we say, equal or, as the trial court said, reasonable pay downs of the obligation and not a balloon, because balloon would be antithetical to everything else in the agreement.
You're agreeing the word reasonable would be applicable here?
Absolutely.
And what's the independent breach? Not paying an equal amount the first time?
Not paying an amount which would reasonably pay down the obligation as reflected by monthly installments required in the contract. Paying, as Your Honor indicated.
But the defense was, or the assertion was, equal payments means, installment payments means equal payments. And the word equal was negotiated out of that contract.
Sure. The word equal is not in the contract. The parole evidence taken by the court regarding that issue, the court found, and we agree, supports actually Dr. Katzman's position that these payments needed to be reasonable pay downs of this $800,000 obligation. And paying down $150 or $1,000 towards an $800,000 obligation, I don't think anyone can determine is reasonable in any manner.
It's kind of interesting because you got lucky because you filed suit 2 months in. 2 months into this agreement, right? After the second payment.
Correct.
Because you got $10,000 the first one, you got $1,500 the second one, you file suit. And you got lucky because then the payments started being reduced.
They were reduced, and
obviously if they went up, you would have lost, according to the court.
And if they were making reasonable payments, then it's possible that we may not have continued.
You would have lost.
And there were other breaches of the agreement. They didn't make a payment out to the right people. They've changed that, so it may not have been.
But what do you say to the case law that there's not an independent action for, unless you filed it, you didn't file a breach of fair dealing and good faith. You certainly didn't file that. It's just a breach of a contract. So, those are tied. Those types of theories have to be tied to some certain action or tied to an action for breach of an express position or provision. So, are you saying that you're arguing that the breach of good faith and fair dealing is tied to breach of the express provision of installments?
Correct. And the cases are pretty clear that good faith and fair dealing is part of every claim and part of every provision of every contract. So that should be incorporated in the breach of contract claim, and there's been no authority cited that says it has to be a separate cause of action. It's part of that breach of contract action.
But it has to be based on a breach. Courts say that, and it's not often explained that it has to be based on an independent breach. Doesn't it usually mean that there was something that all the parties agreed didn't happen, but that's something that was supposed to happen, that performance obligation, the performance of that obligation required some discretion on the act of the party to the contract, and that party to the contract somehow was stymied in its attempt to perform that obligation, but could have exercised good faith in actually accomplishing it. I wish an example would come to mind, but I think the opposing party would say this is a little bit different here because there was not an agreed upon performance obligation that was stymied. They're saying there's no agreed upon performance obligation at all. So the good faith, it can't be the good faith in it's not good faith. In good faith believed it should have been an equal payment, but it is well, we didn't perform in good faith. In other words, good faith is not in how we interpret the agreement, but good faith in how they performed. What did they not do to perform their obligation of paying something every month?
Sure. In order to get around it not being equal, they say, well, it was our discretion to determine that amount. And when they are doing that, they should be paying down this obligation. As Your Honor indicated, there's a default provision. It sort of reflects that there would be some sort of pay down of this obligation as it went forward. They exercised...
Katzman's position was they have to be equal. The agreement says equal. He didn't say they had to be reasonable. The court rejected the equal expectation in favor of a reasonable expectation. And so their argument that the court, by doing that, rewrote the contract seems appealing to me. Tell me why it doesn't carry the day.
Sure. First of all, I think at trial there may have been arguments that the payments needed to be reasonable, but I don't have a record citation to tell you that. The judge, in interpreting and both finding factually and legally that there was a breach, has the opportunity to review the reasonableness as part of the standard, and therefore could use that standard in determining whether there was a breach or not, if that answers your question.
The contract doesn't use the word reasonable. The judge read the word reasonable in through the back door by saying it's a breach of the duty to perform a contract in good faith and in fair dealing. But you don't get there under the case law unless there is an actual breach of the contract, and then that the person wouldn't have had to engage in that conduct that constituted a breach if they had looked at the contract in a certain light.
I think he determined that it's ambiguous, and in order to resolve that ambiguity...
Okay. Who determined it was ambiguous?
I think the trial court did. He didn't explicitly, yes, he didn't explicitly say it in the order, but that was why he went down the road of interpreting the various provisions of the contract, and that's the only reason why he would have conditionally taken parole evidence. And in determining that, in determining whether the provision had to be construed in a certain way, used the reasonableness standard. But I don't think he would have had to have done that even if he didn't find that it was ambiguous. Excuse me.
Okay.
Regarding the counterclaim argument that was filed, there was leave granted by the trial court only to file a limited claim for breach of the confidentiality provision. But A, ComCare's prior breach precluded that, and B, the 9-count complaint that came out of it had other infirmities which were argued before the trial court, and the case should have been dismissed for those reasons as well, the counterclaim. So there, that counterclaim was all otherwise infirm.
You're not abandoning your argument that the reading, I think you said at the beginning, there's a reasonable reading of the contract to understand that the payments that were to be equal. What principles of construction would lead you and us to that conclusion?
Sure. The term monthly installments would there's a reading of that which would reflect equal.
Disregarding the dictionaries.
Well, there were many dictionaries that don't use the word equal, and then there were some that use
They don't
equal.
seem to be very helpful.
Right,
so, yeah,
right, exactly. So then the court can read it, and if you read it based upon Dr. Katzman's reading, which includes the word equal, or ComCare's, which doesn't, the more reasonable and the one that, for example, your example is they could pay 1 cent for 18 months. That's an absurd result. And the cases that we cited in our brief, Vi Finkel and Philip Morris, reflect that when you're trying to determine two ways of reading a contract, you should construe it in one that's more rational rather than absurd.
So, just to make sure I'm following along, or everyone is understanding what I'm thinking, there's two distinct ways that the word reasonable can be used in this imbroglio we have here. One is in the context of the covenant of good faith and fair dealing, was this a reasonable amount each month? or alternatively stated, the court read reasonableness into the contract. Another way the word reasonable is used is, as a rule of construction, you're saying, when it is indeterminate what a provision in a contract means, the reasonable interpretation is the one to pick. Is that what I'm hearing you as a separate argument?
Correct, absolutely. And that's also reflected in the fact that CompCare was asking for a balloon payment or a lump sum payment, which is not reflected in the contract, and then is antithetical to the term installment payment, monthly installment payment, and the default provision, which Your Honor pointed out. Unless there are any other questions from the panel, seems to be a good understanding of it, I'll rely on my papers and request that the district court, or the trial court's order be affirmed.
Okay. And you asked for 3 minutes?
Yes.
I think you were down to 2, but we gave you a lot of questions, so I'm going to bump you back to 3.
Thank you very much, Judge Valenti. We're talking about reasonableness here only because the trial court rejected the only argument that they made in their case in chief to prove a breach of contract. They went all in on this argument that the monthly installment payments had to be equal. And
we can, just to interject very briefly, we can still affirm on that basis, am I correct, under the tipsy coaching doctrine, even though that was not the rationale of the trial court?
Certainly, a tipsy coachman would allow you to affirm on that basis, Your Honor. But in order to do that, you would have to find that an agreement that says that required 18 monthly installments meant 18 installment payments in an equal amount.
Well, did you have to do that? Didn't the court seem to say, well, installment means periodic payments, and it doesn't necessarily include a balloon payment?
Well, it means periodic partial payments.
Okay.
The first payment that CompCare made here was a $10,000 payment.
I go buy a car, I go to the bank, I say I want a loan, I can pay $350 a month at 5% interest. They say, great, it'll take you 7 years to pay that off. I don't make a balloon payment at the end. My last payment is the same as my first payment.
Right, because you have agreed under that circumstance to a specific amount that you're paying every month.
It was an ambiguous agreement then, wasn't it? This agreement was ambiguous. It never used the word balloon payment.
It did not use the word balloon payment.
So
it did not use the word equal. It did not use the word reasonable. It said 18 monthly payments.
The parties had different expectations.
Sure, and if it's ambiguous, then what we do is we look to the evidence of what did the parties intend. And
the judge didn't believe either side.
well,
Apparently.
the judge credited testimony that CompCare was bargaining for flexibility to structure this payment in a way that was consistent with their financial situation. He made some extraneous statements that he thought maybe they weren't doing so in good faith, but ultimately what we're looking at is what is the intent of the parties about what this payment provision required CompCare to do. It required them to make 18 monthly payments. And at the end of the 18 months, they would have paid off the $800,000. Instead, 2 months in, after a $10,000 payment and a $1,500 payment, which was consistent with the idea that everybody knew at the time CompCare didn't have great financial resources, they were sued. You know, if maybe in month 7, the payment, if they hadn't been sued, would have been significantly more. We don't know, but what we know is that it would have been very easy for the parties here if they had intended for the payments to be equal, or if they'd intended for the payments to be at some minimum threshold level, to have just said so. They did not say so. What we also know is that KATZMAN argued the case simply on the basis that the payments had to be equal. And as we detailed at length in the brief, there's simply no basis to find that here. So we ask the court to reverse and remand for an involuntary dismissal and for reinstatement of our counterclaim.
All right, gentlemen,
Thank
it's been
you.
a pleasure. You did a great job. I appreciate it. Thank you for coming. We ready for one more? Keep going? You good?